Most of you probably already know that Jonathan Cain filed a cross-complaint against Neil Sean. I'm going to go over Jonathan's cross-complaint, which he filed on January 13th, 2023, and I'm going to go over Jonathan's opposition to the motion for a preliminary injunction, which he filed on February 10th, 2023. First, this is from Jonathan's cross-complaint. It states, Cain did not make any effort to secure action from the management of the LLC prior to the filing of this cross-complaint, as any such effort would have been futile since the management consists of 50% interest held by Cain and Sean would not have agreed to authorize the LLC to sue him. Nevertheless, in December of 2022, Cain informed Sean's representatives of the ultimate facts of each cause of action alleged herein. Cain requests, pursuant to this court's equitable powers, the appointment of a provisional director and/or receiver to manage Nemota's business and affairs pending the resolution of this dispute, as well as other equitable remedies and rights under Corporations Code, Section 17701.01 et sec, so that the members' interests in Nemota may be preserved and protected from further unlawful conduct by Sean or anyone acting on his behalf or in concert with him. Now, Jonathan Cain said that he made no effort to secure action from the management of Nemota LLC because the management consisted of just Jonathan and Neil. And I find it very interesting that Jonathan Cain requested a provisional director and/or receiver because, according to the documentation in my video titled What's Jonathan Cain Hiding?, Sundoc Filings and the Hughesers have directorship of Nemota LLC. So why does Jonathan Cain feel that they need a provisional director and/or receiver to handle Nemota LLC's business when Nemota already has a director? I believe that Jonathan Cain is trying to pull another fast one on Neil Sean. Now, this is what Griswold Law has to say about provisional directors and receivers. This article reads in part, what is a provisional director? A provisional director is an individual who is appointed by either a board of directors or a judge in order to resolve conflicts between directors, sitting on a corporate board within an organization or company. Although provisional directors are generally seen as a last resort, the role they play is incredibly valuable when a conflict seems unresolvable. Jonathan Cain requested a provisional director and/or receiver under the Corporations Code Section 17701.01 et sec, which is part of the Beverly-Kalia Act. And the Beverly-Kalia Act is no longer. It was replaced in 2014 with the California Revised Uniform Limited Liability Company Act. Now, Griswold Law cited a different code for appointing provisional directors and receivers. Griswold Law reads, when does a provisional director get involved? Provisional directors remedy deadlocked boards of directors or business partners. When these parties cannot come to an agreement about how to move forward about the day-to-day and long-term business of their company or organization, a judge may appoint a provisional director. Court-appointed provisional directors are authorized by California Corporations Code, Section 308, and such appointments arise under two typical scenarios. Now, I clicked on the link Deadlocked, and this is how it reads. Monday, May 13th, 2019. Section 308 authorizes the Superior Court to appoint a provisional director in two different circumstances. Although both involve the existence of a deadlock, the conditions under which a provisional director may be appointed are very different. The first situation involves a deadlock on the board and is the subject of Section 308A. This requires an even number of directors who are equally divided and who cannot agree as to the management of the corporation's affairs. The person seeking appointment must further show that the division and disagreement are such that either the corporation's business can no longer be conducted to advantage, or there is danger that its property and business will be impaired or lost. An action for appointment of a provisional director may be brought by any director or by the holders of not less than 33 1/3% of the voting power, as defined in Section 194.5. Section 308A authorizes the Superior Court to appoint only a single provisional director. The second situation is the subject of Section 308B and involves a deadlock among the shareholders such that they cannot elect directors at an annual meeting. This will be the case when two contending factions hold an equal number of shares. In this case, there's no requirement to show either that the corporation's business can no longer be conducted to advantage or there is a danger that the corporation's property will be impaired or lost. Unlike Section 308A, directors are not authorized to seek the appointment of a provisional director. To seek an appointment, the petition must be made by a shareholder or shareholders holding 50% of the voting power. The court may appoint one or more provisional directors. The reason for authorizing the appointment of more than one provisional director is to avoid creating a deadlock on the board as a result of an even number of directors. Jonathan's request for a provisional director/receiver appears to be invalid according to Griswold law because Jonathan made no mention of a deadlock between directors who manage the affairs of the corporation, and he made no mention of a deadlock between himself and Neil in appointing directors at an annual meeting. Again, according to Griswold law, a provisional director gets involved when there is a deadlock, and they gave the two instances, which doesn't appear to be the case here according to the court document. And Jonathan cited a different code from an act that has been replaced. Now remember, Jonathan Kane requested a provisional director and a receiver, or just a receiver. He wants both, but if he can't have both, he definitely wants a receiver. And here's probably why. Griswold law states, differences and similarities between provisional directors and receivers. There are some similarities between provisional directors and receivers. One of the key similarities is that both positions are required to be neutral third parties. According to Section 308C, a provisional director shall be an impartial person who is neither a member nor a creditor of the corporation, nor related by consular affinity within the third degree according to the common law to any of the other directors of the corporation, or to any judge or to the which such provisional director is appointed. However, receivers and provisional directors have different responsibilities and limitations. A receiver generally has far more authority to make decisions, sell assets, hire contractors, and more. Provisional directors, on the other hand, are limited to their role as a director on the corporate board, having no more or no less duties and powers as any other director. Further, their role may only last for one board meeting, as opposed to a typical receiver assignment that could last several months or years. Provisional directors tend to be less costly and intrusive than a receivership. The next article is by the LLC Jungle. I'm going to read it in part as well. It reads, A Receiver for Your LLC by Kevin Brodell. I'm not sure if I pronounced his name right. April 22nd, 2021. LLC disputes frequently lead to the court's appointment of a receiver under California Code of Civil Procedure, Section 564. The receiver effectively steps into the shoes of the LLC's manager and calls the shots regarding the LLC's operations and assets. Now this is me talking. If a corrupt judge, quote unquote, a corrupt judge appoints a corrupt receiver who will be doing Jonathan Kane's bidding, the receiver will step into Neil Sean's shoes. But Jonathan certainly isn't going to remove his shoes. Jonathan Kane will be calling the shots just as it appears that he's doing now, according to the court papers.
Honey, I'm telling you right now, you steal a loaf of bread from me, you come in my house, I'm going to shoot you with Smith & Wesson. Now I'm going to pray over you. And I'm still going to prosecute you after you're dead and go after your family. So watch. You take $1 billion my mama left me, I'm coming after you. I'm calling up the FBI. I'm going to prosecute you to maximum everything I can go after. I'm going to use every part of any corrupt DOJ. I've got to behave. I've got 3 things in trouble. Corrupt part of a system I can to do you all the way.
Now there you heard Paula. She will seek out any part of a corrupt, quote unquote, corrupt DOJ. And she'll come after your family as well. The article continues to read, here is a quick overview of receiverships for LLCs. Now remember, there's Nemoda LLC and Nemoda Inc. The article continues, the receiver's role. The receiver's role is to preserve the status quo between the parties while litigation is pending. Receivership is a provisional equitable remedy. Receivership is considered an ancillary remedy which does not affect the ultimate outcome of the action. Just like a preliminary injunction, a court can order a receivership even if the dispute is pending in an arbitration forum. The receiver is a neutral agent of the court and not of any party. The receiver acts for the benefit of all who may have an interest in the receivership property and holds assets for the court rather than the parties. Code of Civil Procedure, Section 664. Code of Civil Procedure, Section 664, lists the statutory circumstances supporting the appointment of a receiver. And there was a lot of other text in between there, but I'm going down to the part that's pertinent for my video here. Managerial deadlock or abuse. One of the most common situations justifying the appointment of a receiver in an LLC dispute is where the LLC's management is deadlocked. Some poorly written LLC operating agreements appoint co-managers without any tie-breaking mechanism, which is a recipe for eventual deadlock. See prior post, Why Having Co-Managers for Your LLC is a Terrible Idea. When the co-managers have different opinions regarding the operation of the LLC and are unwilling to budge or compromise, a receiver might be needed to ensure the LLC continues to function. Likewise, when a manager's conduct amounts to abuse or breach of fiduciary duties, e.g., or example, diverting LLC assets, and I believe that's what Jonathan Cain is doing, selling or encumbering the LLC's property without a vote as required by the operating agreement, he could be doing that too. A receiver can be appointed to guard the henhouse while the substance of the dispute is litigated. Disputes regarding membership interests. A receiver can also be appointed to safeguard the LLC, including any funds earmarked for distributions, while the court sorts out disputes regarding the membership roster. Now, this is what I believe is happening. Wind up and asset sales. A receiver might also be useful when an LLC is broken and the members want to part ways, but there is deadlock or extreme lack of trust regarding the liquidation of the LLC's assets. A receiver will typically retain brokers and other third parties to sell real property owned by a dissolving LLC. The receiver might also hire accountants to assist with the distribution of the sale proceeds and reporting of tax purposes. Perhaps this is where Norah Carrington is going to come into play. As I talked about in my other message, you'll have to go listen to the other message if you don't know what I'm talking about here. When divorcing partners cannot manage this process themselves, a receiver can provide an attractive, albeit not cheap, alternative. In light of this document, I believe that Jonathan Cain may be attempting to dissolve Nemoda LLC/Journey and set himself up with a nice retirement plan like the quote-unquote Perry share, the very thing that Valerie and Smith were accused of doing.
Thank you. Thank you, Elder Harold. Thank you all. I'm going to miss you. But I have some breaks, and, you know, leading worship here balances off everything in my life, and I'm in a transition. I'm in a transition now, and God is calling me. Hallelujah. This church is calling me. I will answer with boldness and with resolution. Mostly resolution. I'm resolute for the rest of my life to give my heart and soul to the Holy Spirit. Thank you.
That's a religious con doing that.
He is so phony. Jonathan Cain said that he's in transition. He claims that God is calling him away from Journey and into the church. Now, I told someone months before Jonathan made those statements that he was going to say that God was calling him full-time to the church. But I thought he was going to get kicked out, and then he was going to make those statements. But according to Paula, Jonathan is trying to get out of Journey, but he feels that he can't. But see, he's trying to transition to full-time conning with Paula White and her church con.
John's on the road for 5 months right now. 5 months. Now I'll fly out after Sunday, after the meetings, after church, and I'll fly back by the following Saturday. Do you think that's easy on me? Think it's easy on him? We count the cost. We do. At this point in our life, we could go, we've got goals and purpose and mission for it, and we could say, enough. He always said, I can't get out. So I go, anybody can get out. You can make the change anytime you want. Anything you want out of. You can pretty much get out of anything but prison. I promise you can get out.
I believe that Jonathan Cain has perpetrated a big-time fraud against Neal Schon and Journey, and now he's probably trying to dissolve the LLC before the fraud is uncovered fully and he ends in prison. Now, he may be attempting to dissolve Nomoda LLC/Journey, but I believe that he's going to keep Nomoda Inc. very much alive. This is what I believe. I believe that Jonathan Cain has been transferring funds from Nomoda LLC to Nomoda Inc. without Neal Shon's knowledge. And more than likely, he will eventually transfer the money from Nomoda Inc. to some other accounts that aren't even connected to Journey, and then he'll probably close the Nomoda Inc. account as well. This is from Billboard Pro. In February, Journey's longtime bank, City National, cut ties with the band, according to sources, hampering the group's ability to easily pay its day-to-day touring expenses. Even Journey's official webpage abruptly stopped operating for several weeks in early February before it recently reappeared. Now, the article didn't say exactly why City National Bank cut ties with Journey. Now remember, someone applied for and received 2 PPP loans from the Small Business Administration, and there was an alert attached to those loans which said that it could be potential fraud. Perhaps they found out that it was fraud, and then City National Bank cut ties, since City National Bank was the lender, or maybe it wasn't fraud. It's possible that Jonathan Cain and or his representatives asked the bank to cut ties. It's possible that he transferred the remainder of the money from Nomoda LLC to Nomoda Inc. and then closed the account for Nomoda LLC. Perhaps that's why the bank cut ties, if that's true. And it's possible that Nomoda Inc. could be doing business with a completely different bank on behalf of Journey. And it's quite possible that Paula White applied for those loans, since she was the signatory on one of Nomoda's accounts, and she appears to be very worried about something.
I'm going through something right now. I need God to give me a divine deliverance. I've done everything I know to do. So we're all on this boat together. Because all the people I know, Humpty Dumpty and all his men, and all the king's horses, and all the king's men, can't put this one back together again. And I know some pretty important people. They can't fix it. I need a divine deliverance.
It could be any number of things, though. Perhaps it's because of this. And why is Jonathan Cain trying to get out or leave Journey when he claims that God supernaturally put him in the Journey band, and that every time he performs, he's representing Christ, and they claim that thousands of people are getting saved just by watching Jonathan Cain walk out on that stage and play the piano and the guitar. And they also claim that Jonathan preaches at the concerts and people are getting saved that way as well. So why is he trying to get out if he's doing so much good around the world for the kingdom of God? Why would God tell him to stop such a good work? And they claimed that performing on stage with Journey was Jonathan's mission field, and that Jonathan is a missionary for Christ. I'll do a whole separate video and just put all those videos up there of all the lies that they're telling about Jonathan being a missionary and he's working for God and all of this stuff. But in my video titled, What's Jonathan Cain Hiding?, I stated that from researching, I learned that the person who owns the most shares in the company has controlling power over the company. And I thought that that might be the case with Jonathan Cain and Journey. But after reviewing more of the court documents, I'm not sure if that's the case, but Jonathan Cain certainly fits the profile of a hostile shareholder who has seized control of Journey. The law offices of Stimmel, and Rosier says this: corporate struggles. Who has what power when push comes to shove? To own a corporation without understanding the reins of power available is to miss much of the purpose of ownership and to invite disaster if one of the other owners seek to obtain increased control. That sounds like Jonathan Cain. Or if new owners come into the picture. Further, the death or disability of a shareholder can suddenly result in a new owner, a relative or a spouse, for instance, with more aggressive criteria for ownership. That sounds like Paula White. She hasn't killed him yet or disabled him yet, but she has emasculated him. I'll read that again. Further, the death or disability of a shareholder can suddenly result in a new owner, a relative or spouse, for instance, with more aggressive criteria for ownership, coming into the corporation. Thus, each shareholder should have a thorough knowledge of the workings of corporate power, even if friendship and trust exists between the current shareholders. Now that sounds like Jonathan Cain and Neil Sean at one point in time. The article continues to read, publicly traded corporations have extremely different criteria for achieving and maintaining control, and are not discussed in this article. The article shall concentrate on the typical California corporation not traded on a public exchange and not owned by more than 35 shareholders, husband and wife counting as one shareholder. Now, I don't know if Journey is publicly traded or not. Anyway, the article continues. The basic structure, as discussed in the web article on corporate structure, the typical California corporation has shareholders who elect the board of directors, who in turn appoint the corporate officers, usually a president, CEO, a secretary, and a treasurer, CFO. Typically, the shareholders meet annually to elect the directors and approve their actions. The board of directors meets annually or quarterly to review the officers' actions, and the officers meet as often as necessary to run the entity. Day-to-day operations are run either by the officers or by managers hired by the officers. Since shareholders elect the directors and directors elect the officers, it is apparent that shareholders hold the ultimate position of authority in a company. If one controls how the shareholders will vote, one can determine who will be the directors, who in turn will determine who will be the officers, who will in turn determine who will be the managers of the company. Thus, the first rule of corporate power is quite simple. The person who controls the votes of the shareholders ultimately controls the corporation. Thus, let us examine the details of shareholder voting. Shareholder power, voting the shares. Shareholders determine action to be taken by the company, from election of directors to approval of corporate actions by voting, and normally each share allows one vote. Thus, if a person owns 50 shares, that person has 50 votes. If the person has 60 shares, that person has 60 votes. In California, majority vote controls in votes of shareholders. Thus, if a shareholder has 51% of the stock, that person effectively controls the corporation. This is probably the most important single lesson the business owner must learn in terms of control. Whether one has 10% or 49% matters little. The person who has 51% can elect a majority of the directors, and they in turn can appoint the officers and managers. While certain rights do exist to protect minority shareholders in specified areas discussed below, the simple fact is that the shareholder who controls 51% of the stock is able to run the company pretty much as he or she wishes. Now listen to this. This is particularly important when one recalls that there is no state law obligation of the company to hire shareholders who would thus earn salaries or declare dividends at any particular level of income. Thus, a hostile shareholder, that sounds like Jonathan Cain, a hostile shareholder. Thus, a hostile shareholder owning 51% of the stock can seize control of the board of directors, fire all officers except those he or she wishes, fire all minority shareholders who are employed by the company, hire himself or herself as president, pay himself or herself a good salary, and never declare dividends, using profits to pay bonuses to employed managers and to himself or herself. Now, this could very well be the case. It appears that Jonathan Cain is a hostile shareholder. Even though Jonathan Cain owns only 50% of the stock or shares, he still fits the profile of a hostile shareholder who has seized control of the company and is running the company as he wishes. Illegally, because he's not a majority shareholder, unless Jonathan has tricked Neil into signing away his rights somehow. He appears to have complete control, according to the court documents. If you haven't already, I encourage you to view my video titled, What's Jonathan Cain Hiding? Because, in my opinion, this may very well be the reason, or one of the reasons, for all the director officer changes. The hostile shareholder, Jonathan Cain, has seized control of the company and is running it as he wishes. Now listen to some of the declarations made by Neil Sean, according to the court papers. Neil Sean declares this: "This is just some of the obstruction and unlawful conduct that has been occurring. I have been working full-time and spending my own money to keep moving Journey forward. I do not understand why my business partner will not help me and is working against me." See, he's working against me. This is what Neil Sean said. He can't understand why his business partner is working against him. That's probably because Jonathan Cain fits the profile of a hostile shareholder and a wolf in sheep's clothing. Here's another of Neil's declarations. "The threat of irreparable harm is imminent from this obstruction of account access. I am the president, 50% owner, and a manager of Nemoda. I have a duty to the company, but I am being obstructed from honoring that responsibility because I cannot see what is going on financially at the company, as that has been hidden from me. I have been blocked from Nemoda's Amex records, even though the band I founded and manage is conducting business through Nemoda. I need to be able to see the same records that Cain can see." Neil says that he's president of Nemoda, but according to corporate filings for Nemoda LLC, all the officers were inactivated, including Neil Sean and Jonathan Cain. But Jonathan Cain is the active president of Nemoda Inc. I'll speak more about that later in this video. Here's another declaration of Neil Sean. "Nemoda Amex will be used on the tour for band expenses. I actively manage the band. The situation now with my business partner Cain blocking me from seeing band spending is dysfunctional and damaging. For example, I have been obstructed from accessing spending records for Cain's touring party, which he calls the B party, for prior tour travel. My A party has been completely transparent about its charges. I am also blocked from inspecting the spending of the other cards that have been issued on the account to people who have worked for Journey. I cannot manage Journey under these circumstances. This dysfunction is damaging and hurts the band and Journey brand." See, Jonathan Cain can see what Neil is spending, but Neil can't see what Jonathan is spending. So what's Jonathan Cain hiding? According to the court records, Neil Sean has been blocked out by the hostile shareholder, Jonathan Cain. See, he fits the profile of this hostile shareholder that Stimmel and Rosier described. He fits this profile to a T. Here's another of Neil's declarations. "It was brought to my attention recently by Amex that I was blocked from the Nemoda account. Amex told me that only Cain is authorized to access all records and information for the account. I am only allowed to access records from my own card on the Journey business account. Even as to my own card, only Cain is authorized to make changes and control spending limits. Again, the hostile shareholder, Jonathan Cain, has seized control of the company and is running it as he wishes. In an interview, Jonathan Cain stated that when he first saw the band Chicago, he said to himself that that's what he wanted, was to put together a band like Chicago.
But rock and roll for me was kind of dumb music. Hang on Sloopy, you know, like Wooly Bully. I mean, really? I'm not playing that stuff. Go to my first rock concert in Chicago, and I see these guys, I'm like, oh. I was just blown away. I'd never seen anything so good. And the precision, you know, I thought someday I want to put a band together like that and get that crazy. You know, I knew that they were onto something really great, and they had really paid their dues, and they were kind of like my role model.
So it appears to me that Jonathan Cain basically has stolen Journey from Neal Schon, since he couldn't put together his own band. Now, from reading Jonathan Cain's cross-complaint against Neal Schon, it appears to me that Jonathan Cain put his long-time takeover plot into action in 1998. The cross-complaint states this. Jonathan Cain is declaring this in his cross-complaint. Nomoda was formed in or about May 1998. While there have been changes to the membership since 1998, Cain and Schon are currently 50% co-owners of Nomoda. In or about 1998, an American Express Platinum corporate credit card in the name of Nomoda was issued. Amex account. Cain is the personal guarantor on the Amex account. It is tied to Cain's Social Security number, and Cain is personally liable for all expenses on the Amex account. Now, Neal Schon declares this. This is what Neal Schon is declaring. Nomoda's Amex account was set up by Cain without Schon's consent or knowledge, with only Cain as the account holder. Cain set up the account so that only he is authorized to access the records and information for the account. Cain has blocked Schon from access. Amex has informed Schon that it cannot release information to Schon. This obstruction of access has been concealed. Amex was the first to notify Schon of the improper setup of the Nomoda Amex account and that Schon's access has been obstructed by Cain. Schon has repeatedly demanded that Cain authorize him to have full authority to directly access Amex's records for Nomoda's account. To date, Cain has not done so. As a result, Schon is left with no choice but to bring this action to enforce his rights and authority as a manager and member of Nomoda. See, it appears that Jonathan Cain has been holding Journey hostage since 1998. The hostile shareholder. So Nomoda LLC was formed in 1998, and Jonathan Cain unilaterally opened what basically amounts to a joint bank account for Nomoda LLC and himself. In my view, that's how it appears. So I went online and I checked out personal guarantor for business accounts. And this is what I found. This is by U.S. News. I'm going to read this article in part as well. It says, "Can I get a business credit card with no personal guarantee?" Under the photo, the caption reads, "Almost all business card lenders require a personal guarantee as proof you are invested in your business." The photo was by Getty Images. But the article goes on to read, "If you own a small business, you're probably used to separating your business and personal finances. But the two may intertwine when you take out a business credit card if the issuer requires a personal guarantee," which obviously they did. I believe that's what happened with Jonathan Cain. He intertwined his personal finances with Nomoda Journey's business finances probably ever since he opened the account in 1998. And that's probably why the hostile shareholder is blocking Neal Schon from reviewing the business records. I'm going to continue reading. "A personal guarantee is an agreement an owner or executive makes to pay back a debt if the business cannot. It acknowledges that you'll personally pay for charges on the business credit card if your business doesn't have the cash flow to make on-time payments. If your business defaults, the issuer could go after your personal assets, even if you leave the company, or even if you leave the band. Maybe that's why Jonathan Cain feels that he can't leave Journey. He can't get out. That's why I find it hard to believe that the bank would cut ties rather than going after Jonathan's personal assets first. And as far as I can tell, Jonathan Cain never stated that he had been personally covering the expenses of the company. So if Jonathan Cain hadn't been personally covering the expenses, then I would assume that the bank didn't come after him personally. Again, I think Jonathan is just trying to, he probably has been committing fraud, and now he wants to shut down the company, or like I said, the bank may be found fraud in those PPP loans. I'm not sure which one. But it appears that Jonathan is hiding something, and he's running from something. Now, according to U.S. News, even if Jonathan did leave Journey or get out, as Paula put it, he's still responsible for Journey's debts, no matter how many millions of personal expenses anyone racks up. Jonathan Cain is still liable. That's why I believe that Jonathan might be trying to dissolve the LLC. And that's why I believe that it's quite possible that Jonathan Cain requested the bank to cut ties. Like I said earlier, it's quite possible that Jonathan transferred all the money from Nemoda LLC to Nemoda Inc. and then closed the Nemoda LLC account. And Nemoda Inc. probably does business with a completely different bank other than City National Bank. Or it's possible that it could be doing business with City National Bank. I don't know. But Nemoda Inc. has to be doing business with some bank. The article continues to read, how personal guarantees work. When you apply for a business credit card, the issuer may ask for an employer identification number and financial information for the business. If the card includes a personal guarantee, then you'll also need to provide your social security number and allow a personal credit check. You can find out whether a business credit card requires a personal guarantee by reading the card agreement and searching for the term liable or personally responsible. Cards that need a personal guarantee will include a clause noting that both the business and the individual applying for the card on behalf of the business are liable for payment of the balance. If the clause says you're jointly and severally liable for the debt, that means as the cardholder, you're responsible for 100% of the debt, even if you only own 50% of the company. Unclear about the terms? Call the issuer and ask for an explanation. You'll want to understand everything before you sign the cardholder agreement, as you're effectively co-signing the account. Business owners may dislike personal guarantees because of the liability involved. If you default on payments, the issuer can go after your personal assets, and your company's business structure can't protect you, whether it's a sole proprietorship, a limited liability company, or another type. Once you accept the personal guarantee agreement, it overrides any liability limits that come with the classifications. See, the article stated that when an owner or officer of the corporation or LLC signs a personal guarantee agreement, their business and personal finances may intertwine, and the owner or officer is a co-signer on the account. So that's far more than a joint account then. Now, after Neil allegedly went spending wild, so to speak, Jonathan limited his spending to $30,000 per month, according to Jonathan's declarations, which states, in order to protect our liability to cover the band's expenses, I requested that Amex limit the charges on Sean's card to $30,000 per month. This infuriated Sean, as he apparently had no other ability to fund his extravagant lifestyle. Now, he limited Neil Sean's spending amount to $30,000 per month. So what amount did Jonathan Cain limit himself to spend on the company credit card? What's Jonathan Cain's limit? He won't say. Here's another declaration of Neil Sean. Nemoda has an Amex account with multiple cards that are used to pay for Journey expenses. This is not a personal account of Cain. It is a company account used for Journey. Millions in Journey funds have flowed through this account for decades. Now, Neil Sean said that multiple cards are used to pay Journey expenses. Now, according to Neil Sean, Shane Glass was hired by Jonathan Kane alone and is Jonathan's accountant, even though Jonathan Kane claims that Glass is the company accountant. This is Neil Sean's declaration, according to the court documents. Shane Glass works for Kane, not Sean or Journey. Kane's motion states that Shane Glass of the Colony Group, LLC, was retained to act as the co-business manager for Journey pursuant to a written agreement dated June 29, 2022. However, I never hired Shane Glass or TCG and did not sign the agreement referenced by Shane Glass. Shane Glass and TCG were hired only by Kane and are his accountants. See, Jonathan Kane, according to the court documents, hires an accountant as a third co-business manager of the company, according to Neil Sean. And Jonathan stated that Neil signed the papers, and Neil says, no, he didn't sign any papers. That Jonathan hired this man alone. So Jonathan hires an accountant as a third co-business manager of the company, according to Neil Sean. And then, according to the LLC Jungle, it's a terrible idea to have just two business managers. And Neil said that he never signed an agreement to hire Shane Glass. So the hostile shareholder, Jonathan Kane, has seized control of the company and is running it as he wishes. Remember, Neil said that there were multiple cards. Now this is Neil Sean's attorney declaring the following. The records provided by Shane Glass were substantially incomplete. Our office just recently obtained a production from Amex in the response to the subpoena we issued. I have conducted a preliminary review of the production and compared the records produced by Amex to those previously provided via Dropbox by Shane Glass. That comparison shows that the production by Shane Glass was substantially incomplete and included only a fraction of available Amex records. The records provided by Shane Glass only goes back to 2018. The production by Amex, however, includes records going back to 2001. Attached hereto as Exhibit A, for example, is a copy with redactions of a page from Amex production consisting of a record from July 2001. I have also identified at least 9 additional cardholders on the account in the production from Amex, whose records were not included in the records from Shane Glass. Apparently, Shane Glass, Jonathan Kane's accountant, withheld 17 years worth of financial documents, and he withheld the names of 9 other cardholders on that account, according to the court papers. Now, most likely, Shane Glass was following the orders of Jonathan Kane or his representatives. See, he withheld 17 years, I'll say it again, I will repeat it. He withheld 17 years of financial documents. Or maybe that's all that Jonathan Kane submitted to Glass. Maybe Jonathan Kane hid the rest of the records, just like he's hiding them from Neil Sean. And 9 other people that have cards, 9 other card holders on that account, people who are spending on the Amex account. Now, clearly, Jonathan Kane is hiding something. 17 years of documents. Do you realize how much paperwork that is over a 17-year period? And how many millions of dollars could possibly have been transferred from Nomota LLC to Nomota Inc. or some other bank account or accounts over a 17-year period? Surely Jonathan Kane is hiding something. Now, Jonathan's cross-complaint states this. Now, this is Jonathan Kane. Cross-complainant, or Jonathan Kane, is informed and believes and thereon alleges that while Sean may have once had a gold card on the Amex account, Sean first obtained a platinum card in his name on the Amex account in or about May 2021. Sean's Amex card. Prior to that time, Sean never expressed an interest for an individual card on the Amex account. It was about this time, or in the summer of 2021, Kane was informed by Journey's business manager that Sean had serious financial problems as a result of an extravagant lifestyle and could not keep up with his expenses. See, the business manager was reporting to Jonathan Kane about Neil Sean's spending habits. Now remember, according to Stimmel, and Roser, business managers report to the directors or officers. And it says that the day-to-day operations are run either by the officers or by managers hired by the officers. But according to Open Corporate's database, Jonathan Kane, Neil Sean, and Ross Valerie were all inactive as directors and officers, according to the corporate filings dated December 2020 through March 2022. But Jonathan Kane remained the active president of Nemoda Inc. So it appears that that business manager was hired by Jonathan Kane, or is under Jonathan Kane's control, because managers are supposed to report to directors or officers. And according to corporate filings, Sundoc Filings and the Hughesers have directorship of Nemoda LLC. So it appears to have been Shane Glass, the third co-manager accountant who reported on Sean. It may not have been him, but that's how it appears to me. See, the hostile shareholder, Jonathan Kane, the hostile shareholder president, is running the company any way he wishes. Now remember, Jonathan Kane stated in his cross complaint that Sean first obtained a platinum card in his name on the Amex account in or about May 2021. And prior to that time, May 2021, Sean never expressed an interest for an individual card on the Amex account. So Neil Sean never expressed an interest in having a company credit card in his name until, for the first time, according to the court documents, in May of 2021. Therefore, Jonathan Kane and whoever else issued Neil Sean a business credit card with his name on it in May 2021. Jonathan's cross complaint states this: from May 2021 until the fall of 2022, Sean has caused over $1 million in personal expenses to be charged to the Amex account. Sean's use of the Nemoda Amex card for personal expenses created serious liquidity problems for the band, as the Amex balance had to be paid every month, and there were insufficient revenues to pay for other expenses, as Sean saddled Journey with over $1 million of his personal expenses. Okay, now check this out, people. So from May 2021 to the fall of 2022, Sean allegedly racks up $1 million worth of debt for the Nemoda Journey account, which left insufficient funds to pay for other expenses related to the company. Now, I find that incredibly hard to believe. Not the money being spent, but that Journey had insufficient funds to pay other expenses. Now, I read somewhere online that one of Journey's tours, I don't remember which year it was, but it was some years past, but just from one tour, the band brought in, I believe it said something like $70 million, just for one tour in 1 year. Then factor in all the money that they brought in from all the other previous years that they toured, and factor in all the money that Journey brings in from selling records, CDs, Journey clothing, jewelry, etc., whatever else business they're in. Factor in all of that money. So if Neil spent Journey's last $1 million from 2021 to 2022, what happened to all the millions and probably billions of dollars that Journey accumulated from 1998 up until May 2021? Neil didn't get his card and allegedly go spending wild, so to speak, until 2021. So who had a card or cards and apparently went spending wild from 1998 until May 2021, leaving only $1 million in the company account? Now remember, according to Neil's attorney, he identified at least 9 other card holders, which Jonathan Kane failed to disclose. So again, if Journey didn't have money enough to pay their other expenses because Neil squandered away Journey's last $1 million, then who squandered away all the rest of the Journey's money before Neil got his hands on it? Again, how is it that Journey only had $1 million to its name? I find that incredibly hard to believe, that $1 million broke the bank. And if it did, then someone else had already broke the bank before Neil got his hands on the last $1 million. So who are these other 9 people? And how much did they spend? Jonathan Cain undoubtedly has a card, since he opened the account in the first place. And remember, Paula White could have broke the bank in 2020. According to Neil's complaint, it states that, in addition to Cain's withholding of my profit distributions, I also recently learned that Cain improperly added his wife Paula White as an unauthorized signatory on a Journey bank account. Cain's wife has no involvement with Journey and should not have any financial authority as to Journey, and as previously agreed between myself and Cain and ruled on by the Honorable Barry Baskin in 2021. No other person, party, or trust was to be added to any Journey business. Cain has manipulated the business for his own gain by adding his wife behind my back to the business I began in 1972. See, Paula White probably has or had her own personal card as well. Who knows? There may be more than 9 others. The attorney said that he identified at least 9 other card holders. Maybe he just hasn't found those other ones yet. If there be any others. Could possibly be. I mean, Jonathan Cain could have had several cards in his other aliases as well. He could have had a card in Jonathan Cain, a card for Jonathan Cain Frigga, a card for Jonathan Frigga Cain, a card for John L. Frigga, a card for Jonathan Leonard Frigga Cain. So he could have had several cards in his different aliases. And like I said, there could be more than 9 others. But who were these other 9 people that were spending off that same account? So it could have been them who spent all the money and only left $1 million in there. And then Neil allegedly comes along and spends the last $1 million. So who spent all those other millions and possibly billions of dollars over the last, 25, 27, or how many ever years it was? And then, according to Billboard Pro, Journey brought in $31.9 million, almost $32 million in 2022 alone. Now let's focus on just 2022. So if that's correct, and Neil spent $1 million, what happened to the other almost $31 million? Was it deposited or transferred to Namoda Inc.'s account, since Jonathan Cain is in transition? It's possible that Namoda LLC had several different accounts with several different banks, with corporate credit card accounts. I mean, even there's so many possibilities, but you'll never know if Jonathan Cain never opens the books to see. You'll never know what he's doing, because the hostile shareholder has seized control of the company and is running it as he wishes. But now listen to what Neil Schon declared. He says, I have no issue with being charged back for my personal spending on tour. This is what has always happened with the band on tour. At the end of the tour, personal spending of band members is charged back to the respective members as deductions from profits distributions. Cain claims that on the last leg of the tour, I incurred more than $1 million in personal spending. This is false. Cain improperly categorized hundreds of thousands of dollars of band spending as personal spending. Attached hereto as Exhibit A is a summary of the band spending that Cain improperly allocated to me as personal spending, which I helped my accountant to prepare. As this summary shows, at least $421,534 in band expenses were allocated entirely to me as personal spending, increasing Cain's pay and decreasing my own. Sean goes on to declare in his complaint, during the last tour leg, Cain abused this process by requiring the band's financial managers at the time, now terminated, to allocate hundreds of thousands of dollars in spending for the band to me personally. This spending includes items such as band promotional photography, band security, and salary for Journey crew. These are band expenses, not personal expenses, but were charged to me as if they were personal spending. As a result, my profit distributions were withheld and Cain was overpaid. In other words, I was personally shouldering paying for Journey crew and other band expenses. See, so it appears that Jonathan Cain purposefully and improperly categorized expenses to increase his own pay. See, that's what happens when Judas is in charge of the money bag. The hostile shareholder runs the company any way he wishes. And this might explain part of the reason why.
But where I'm like, I'm going to go home tonight, I'm going to kiss those kids, I get to see Brad there next door, and I'm going to be so happy, and I'm going to watch Rocco mope in depression as a reminder, that's my German Shepherd, that John's not there. I'm like, don't feel sorry because I'm so married to him, it's good. Boy, you better bank while you're out there, you better bank, buddy. This better be worth it, you better bank. Come on. Why are you looking at me funny? He better bank. Like, he better not come home empty. Be gone from me for 5 months. Why are y'all looking at me funny? But boy, bank it. You heard that. Somebody send this tape to John. Bank it. Y'all heard me on Wednesday. John, you gonna be out? You better bank it. Bank it. Bring home the bacon, buddy. For real. Y'all like, oh, I just pray for him out there and let him go. No. No. I pray for him. But you better bring home a big check. You're going to be gone from me for 5 months and out in that kind of heck.
See, you better bring home a big paycheck. Even if it means purposely miscategorizing expenses and withholding parts of Neil's profits and maybe parts of Arnell's profits and parts of Dean's profits and whoever other band members there are, but you better bring home a big paycheck. You better be banking it, that's for sure, says Jezebel. Now this is from Jonathan's cross complaint. As a result of Sean's use of the Amex card for personal expenses, whereby Sean charged over $1 million in personal expenses to the Amex account, Sean was unjustly enriched at the expense and to the detriment of both Nemoda and Cain. Now, wait a minute. Jonathan Cain and his wife, Paula White, have been using the church, the house of God, no less, to unjustly enrich themselves for years at the expense and to the detriment of church members and donors worldwide. For years they have. Ezekiel chapter 22 verse 27 says, her princes in the midst thereof are like wolves ravening the prey, to shed blood and to destroy souls, to get dishonest gain. Ezekiel chapter 22 verse 13 says, behold, therefore I have smitten mine hand at thy dishonest gain which thou hast made, and at thy blood which has been in the midst of thee. They have been unjustly enriching themselves and getting dishonest gain from the church, from the house of God, and from church members who they claim are their brothers and sisters. We just love you, my church family, and donors worldwide, to get dishonest gain. And according to the court documents, it appears that Jonathan Cain has been unjustly enriching himself at the expense and to the detriment of Nemoda, / Journey, / Neil Sean, / all the other band members, present and past. Now, Cain's cross-complaint states this. Cain, both individually and as a member of Nemoda, seeks restitution from Sean, and in order for Sean to disgorge all profits, benefits, and disguised dividends he obtained as a result of his wrongful conduct, conversion, fiduciary breaches, and or abuse of his position, as it would be inequitable for Sean to retain the benefits that were unjustly and improperly obtained. Now, can you believe that? After they've been ripping off the church for all these years. And according to these court documents, Jonathan Cain clearly has been abusing his position. See, Neil Sean needs to seek an order for Jonathan Cain and his wife Paula White to disgorge all their profits and benefits that they unjustly obtained from Journey starting from 1998, when Jonathan Cain unilaterally opened an account in Amoda's name, to which he alone has access to the account and company records, according to Neil Sean and according to Jonathan Cain himself. And above all, Jonathan Cain and Paula White need to disgorge all the profits and benefits that they've conned from church members and worldwide donors over the past 37 years, respectively. So, if you haven't, again, I'll say it again, if you haven't viewed my video titled, What's Jonathan Cain Hiding? Do so, because Jonathan Cain and Paula White are operating several LLCs and fictitiously named entities from their home addresses and the church's address. And here's another LLC which Paul is operating from Addiction Sound Studios address in Nashville, Tennessee at 506 East Iris Drive, Nashville, Tennessee, with Nevada jurisdiction. It's called PS 374 LLC. And Paula White is the manager there. It was incorporated on June 5th, 2017. Wiki Corporation says PS 374 LLC filed as a domestic limited liability company in the state of Nevada on Monday, June 5th, 2017, and is approximately 6 years old, as recorded in the documents filed with the Nevada Secretary of State, who owns PS 37 LLC, and it shows Paula White. And the address for PS 374 LLC is 506 East Iris Drive, Nashville, Tennessee. And then, according to Open Corporates, there's another company with the exact same name, PS 374 LLC, but it's being operated by the Bodys, Mark and Ruth Bodie. And it was incorporated October 26th, 2020. But it has the exact same name as the one that Paula owns and was incorporated in 2017. So clearly those two corporations, and Paula White and these two people, are connected in some way. And then there's Worship in the Now Ministries, Inc., another business where Paula was pastor in 2017, but she has since changed her title to director. And then there's the fictitious entity called Now Church, which is owned by Worship in the Now Ministries, where Paula White is the director. Now, I know you know the definitions of words, but I like to give the definitions. Fictitious. Created, taken, or assumed for the sake of concealment. Not genuine, false. Concocted or fabricated, especially in order to deceive or mislead. Feigned, imaginary, not real, fabulous, counterfeit, and false. See, that's why Paula uses a lot of fictitious entities, for the purpose of concealment, to deceive and to mislead. Here is another of Neil Sean's declarations. I need access to the Nemoda Amex account immediately for another reason, to make sure I am paid my profit distributions from touring. My and Cain's tour spending is determined in part by reviewing the Nemoda Amex records. Personal charges incurred by myself or Cain are then deducted from our respective revenue shares. This means that I can only know the amount of Journey revenue to which I am entitled if I can access the Nemoda Amex records for both myself and Cain. So it appears that Sean has no way of knowing whether he's being ripped off or not. But I'm sure he knows he's probably being ripped off. He just doesn't know by how much exactly, because the hostile shareholder, Jonathan Cain, is blocking him from seeing the company financial records. And according to Sean, it's standard practice for both he and Cain to put personal charges on the Amex card and then later deduct the charges from their earnings or profits. Another declaration of Sean, he says, Cain's accusations of reckless spending are false. Cain also claims in his opposition that I have engaged in reckless personal spending using corporate funds. This is also not true. In fact, my pay has been withheld, and Cain has received excessive compensation because of his abuse of Journey's accounting. See? The hostile shareholder with no oversight. Another of Sean's declarations. According to the court records, my profit distributions have been withheld based on incorrect claims about my personal spending relative to Cain's personal spending, but Cain is blocking me from seeing his personal spending. I cannot access the Amex records these incorrect claims about my spending were supposedly based upon. I make my living from touring. Withholding my income threatened my livelihood. I could not timely make payments on my obligations and my credit was damaged. I need access to the Amex records so I can make sure my pay is not blocked again. This is just some of the obstruction and unlawful conduct that has been occurring. I have been working full-time and spending my own money to keep moving journey forward. I do not understand why my business partner will not help me and is working against me. See, Sean's spending relative to Cain's spending. So why won't Jonathan Cain disclose his personal spending? So that there can be a side-by-side comparison. Again, see, according to Sean, he can't see Jonathan Cain's band Party B spending. He can't see Jonathan Cain's personal spending. He can't see anyone else's spending. All Neil Sean can see is what Neil Sean is spending. That's what Jonathan Cain allows him to see. So clearly Jonathan Cain is hiding something. Clearly he's hiding something.
The Bible makes very clear that there are two battle lines that are drawn. Amen? That there are two kingdoms in operation. God's kingdom, the kingdom of God, which is light and righteousness, and the kingdom of Satan, which is darkness and wickedness. At all times your life is operating on one or the other. You're either yielding to the kingdom of God or to the kingdom of darkness. Listen, if it's not darkness, you don't have anything to hide.
St. John chapter 3 verse 21. But he that doeth truth cometh to the light, that his deeds may be made manifest, that they are wrought in God. See, the hostile shareholder, Jonathan Cain, is blocking his partner from viewing his personal spending and band spending. Why? Jonathan Cain is probably outspending Neil Sean. See, Jonathan Cain casts suspicion upon himself. Why doesn't he make his deeds manifest? So that people will know that he's an upstanding, upright business man of God, as they claim. And Jonathan may not even be deducting his personal spending from his own profits. And that's probably one of the things that Cain doesn't want Sean to see. Again, Jonathan Cain casts suspicion upon himself. Clearly he's hiding something. Another of Sean's declarations. Sean is blocked from accessing complete Amex records. Jonathan Cain claims in his opposition brief that I can access all Amex account records because I am an account manager, limited access. This is not true. As I explained in my prior declaration, I spoke to Amex on October 27, 2022 and requested equal access to all records for all cards on the account. I was told by Amex that Amex still could not provide these records to me per Cain. Amex informed me, see, they were following Jonathan Cain's instructions. Amex informed me that I was not entitled to request complete historical paper records for the account because I had only limited access. With limited access, I am unable to access complete records for the account or all cards on the account, either online or by direct request to Amex per my call with Amex. See, Sean has limited access. Sean can only see what Jonathan Cain wants him to see. Now, if there was no wrongdoing on the part of Jonathan Cain, and if Jonathan Cain had nothing to hide, he would open the books and allow the man to view all the company business and financial records, which he's legally entitled to see as 50-50 owner of the company. Now, in Jonathan Cain's opposition to Sean's motion for a preliminary injunction, this is what Jonathan Cain said. There is also the matter of Sean's unclean hands. Sean has the audacity to seek equitable relief after improperly charging more than $1 million of his personal expenses to the Amex account for Nemoda LLC. Now, this is the case law that Cain's attorney cited in their opposition paper regarding the doctrine of unclean hands. It says the overriding concept to precluding recovery to the unclean plaintiff protects the courts rather than the opposing party's interest. And then they gave case law Michaels at 533. The clean hands doctrine generally prevents a party from obtaining either legal or equitable relief when that party has acted inequitably or with bad faith relative to the matter for which relief is sought. And then they gave another case law, People versus Wickham. And in People versus Wickham, the court stated this: the unclean hands doctrine is not a legal or technical defense to be used as a shield against a particular element of a cause of action. Rather, it is an equitable rationale for refusing a plaintiff's relief where principles of fairness dictate that the plaintiff should not recover regardless of the merits of his claim. It is available to protect the court from having its powers used to bring about an inequitable result in the litigation before it. Now, Jonathan Cain says that Neal Schon has unclean hands. But Jonathan Cain has unclean hands as well. Among other things, what about Jonathan Cain improperly categorizing and charging company expenses to Neal as personal expenses, and refusing to disclose his own personal spending and ban Party B spending, and refusing to let the man review the records of the company which he owns? And he's refusing to disclose 17 years of financial records. And Jonathan Cain is far worse because he's claiming to be a Christian, a so-called minister, a pastor who holds conversations with God. And God told him to do this, and God told him to do that. And he prophesied the second coming of Paula White Cain. God told him. That's blasphemy. They love to lie on God. Isaiah chapter 59, verse 13. In transgressing and lying against the Lord, and uttering from the heart words of falsehood. It's a wonder God hasn't struck these lying people. This is from Jonathan Cain's cross complaint. He says this as well: by virtue of the fact that Schon and Cain were and are and have been at all relevant times members, managers, and co-owners of Nemoda, a California LLC, Schon owed unqualified fiduciary duties of good faith, care, and loyalty to Cain, pursuant to inter alia, or pursuant to, among other things, California Corporations Code 17704.09, as well as common law and the agreements governing Nemoda. Again, the Beverly-Kalia Act was replaced in 2014, and this code 17704.09 is a part of the Beverly-Kalia Act as well. But that sounds like someone who's delusional, straight up psychotic. But even if he had cited the correct code, the duties of good faith, care, and loyalty are supposed to work both ways.
I believe that blessings are meant to be paid forward. In other words, when God gives you something as mighty as like a chance and an opportunity to be in a band Journey, I was selling stereos, 2 years before that, making no money at all. I made my first million, first year I was in the band. And I never forget, they wrote the $1 million check, and I wow. I thought I was going to cry. And that we'd be in heavy rotation all over the world. And it was just so cool to have gotten one shot with these guys and have it soar like that and just have it explode first time out with a band I hadn't made a note with. And to stand on the stage at the Rock and Roll Hall of Fame was the pinnacle for me, I'll tell you that.
Now, according to Jonathan Cain himself, Neal Schon picked Jonathan Cain up from selling stereos and hired him as part of the Journey band. And as a result, Jonathan attained worldwide fame and received his first $1 million paycheck from Journey. See, Journey transformed him into a famous millionaire the very first year that Neal Schon brought him into the band, according to Jonathan Cain himself. You heard him. And he's now 50-50 owner of this iconic band to boot. I have to agree with Sean's wife when she posted on Facebook that Jonathan Cain was biting the hand that feeds him. And now it appears that he's trying to bite off the head. Going for the head now. Going for the head. In my other video, I stated that I couldn't understand how anyone would go into a 50-50 partnership with Jonathan Cain, fully knowing that he was married to Paula White. Well, after reading more of the court records, it clarified that for me. The court record states this. This is Neal Schon's part of his complaint. I was recently in this court protecting the band I built from an attempted coup. The lawsuit was Neil Sean et al. And the et al. Was Jonathan Cain. So it was Neil Sean and Jonathan Cain versus Ross Valerie et al., which was Ross Valerie and I think his name is Steve Smith. Case number whatever. In early 2021, we entered into a confidential settlement. As a result, Cain and I essentially became 50-50 owners of everything related to Journey. I serve as the president of Journey and its corporate entities. One of the Journey companies I own with Cain is Namoda LLC, a California limited liability company established in 1998 as an operating entity for Journey. Cain and I each own 50% of the membership interest in Namoda. We are also equal co-managers of Namoda, and attached hereto as Exhibit A is a true and correct copy of the 1998 operating agreement of Namoda. And in my other video, I also stated that I believe that Jonathan Cain orchestrated the other lawsuit that caused the removal of the other two band members, divide and conquer. Now I believe it all the more in light of this court document. I believe that Jonathan Cain knew that if he got rid of those other two band members / shareholders, it would automatically put him in a position as a 50-50 owner. Yeah, I do believe that was Jonathan's plan all along. He probably manipulated those two band members into doing what they did, and then manipulated Sean into suing them. Now, it appears that Jonathan Cain is vying for 100% ownership. See, 2 down and 1 to go. From reading the court documents, though, you would think that Jonathan already is the sole owner of Journey, the way he's operating it. See, the hostile shareholder has seized control of the company and is running it the way he wishes. Here's another part of Jonathan's cross-complaint. Pursuant to those duties, Sean was required to act as a reasonably careful co-owner would have acted under the same or similar circumstances, was required to act in the highest good faith toward Cain, was required to act in Cain's best interest, and owed a duty of loyalty to Cain. Further, Sean was obligated not to engage in self-dealing transactions that benefited only himself or to waste valuable corporate assets. Jonathan said that Sean was required to act in Cain's best interest. Now, again, isn't that supposed to work both ways? And according to these court papers, Jonathan definitely hasn't been acting in Neil's best interest, and probably not Journey's either. And in my view, Jonathan Cain is the one who's acting in bad faith. All the way around, from the day he started Namoda LLC and then Namoda Inc. and Elmo Partners Inc. and all those other companies where he's president and or chief financial officer. See, it appears that Jonathan Cain has always acted in his own best interest over anyone else. So, technically, Jonathan Cain seized control of Journey through what clearly appears to be fraudulent means in 1998 when he started Namoda LLC, and especially when he started Namoda Inc. in 2004. And I find it interesting that Steve Perry left the band in 1997, but there's another document that says he left in 1998. But very soon after Perry left, the same year or the next year, Jonathan Cain starts Namoda LLC in 1998 as the operating entity for Journey, and then opens a business credit card account the same year with himself as personal guarantor and the only person that has any control over that account. Not like that seems very, very, very suspicious to me. And I must say that it's possible that Jonathan has something to do with Steve Perry leaving the band as well, because no sooner than Steve left, Jonathan opened the account. And according to Neil Sean, Jonathan opened the account without his knowledge and consent. He didn't even know about it. And he opened it in such a way that only Jonathan has full access and control of the company's finances. He says, Namoda's Nomoda's Amex account was set up by Cain without Sean's consent or knowledge, with only Cain as the account holder. Cain set up the account so that only he is authorized to access the records and information for the account. Cain has blocked Sean from access. Amex has informed Sean that it cannot release information to Sean. This obstruction of access has been concealed. Amex was the first to notify Sean of the improper setup of the Nomoda Amex account and that Sean's access has been obstructed by Cain. Sean has repeatedly demanded that Cain authorize him to have full authority to directly access Amex records for Nomoda's account. To date, Cain has not done so. As a result, Sean is left with no choice but to bring this action to enforce his rights and authority as a manager and member of Nomoda. I read that earlier. See, he's clearly been acting in bad faith and only caring about himself from the very beginning for the past, whatever, how many ever years, 25, 27 years. And he says that Neil Sean has unclean hands. I don't know what kind of hands he has, but you can clearly see on his face right here in this lawsuit that Jonathan Cain's hands are filthy. His hands are filthy. What is the hostile shareholder hiding? And at that time, in 1998, Jonathan was only like maybe 1/5 or 1/6 owner of Journey. So you can imagine what he's doing now as 50-50 owner. So, yeah, it appears that the hostile shareholder, Jonathan Cain, seized control of Journey through fraud and trickery, and he's been holding Journey hostage for the past, 25, 27 years. See, that should be a prosecutable offense, no matter how many years have passed. No one should be allowed to just slither in and seize control of someone else's lifelong accomplishments. And talk about ungrateful. Yeah, I do believe that Jonathan Cain pulled a long con on Neil Sean. And like I said earlier, I think now it has caught up with him, and now he's trying to get out. And I believe Jonathan Cain is doing the very thing that he accused Valerie Smith of, trying to get the Perry share, or even better. And like I said earlier, it's quite possible that Jonathan Cain transferred all the money from the Nomoda LLC account to the Nomoda Inc. account and then closed the Nomoda LLC account. I could be wrong, but it is a possibility. I could see that happening easily. I mean, he didn't open Nomoda Inc. for nothing. And he's probably been transferring money all along, like I said, since 2004. And he could have been transferring money to his own personal bank account since 1998. Because, remember, Neil Sean said that millions of dollars had been flowing through that account for decades. Jonathan Cain fits the profile of a hostile shareholder with unclean hands, and he has seized control of the company, and he's running it as he sees fit. I mean, there's a lot more that could have been said here, and you may have picked up on some things that I didn't pick up on, but in light of those articles that I read and the video clip of Paula, I believe the hostile shareholder, Jonathan Cain, wants a receiver because he's attempting to dissolve Nomoda LLC and then leave Journey. The hostile shareholder has seized control of the company and is running it as he wishes.